Good afternoon to everyone present here, all the participants. Welcome back to the day 5 of our national level FDP on emerging trends in technology future perspective. So I welcome you all for the last day of our FDP program. I welcome our speaker of the today's program, Vijay Krishnan sir. So to welcome today's speaker and the gathering, I request Dr. S.G. Saida Tabassum, Assistant Coordinator IQAC and HOD Department of Commerce, to do a formal welcome to the guests and the participants of today's program.
A very good afternoon to everyone. At the outset, I extend my cordial welcome to Mr. Vijay Krishnan, the resource person of this session. Mr. Vijay Krishnan is an experienced intellectual property rights professional with keen interest in patent search tools and workflows. He is registered as Indian Patent Agent and currently working as Intellectual Property Analyst with Philips India Limited. Prior to joining Philips, he worked as IP Manager at Relucra Technologies. He also led an IP services team at Skytech Patent Art Services, and he was an IP licensing professional at Vestas. He has more than 15 years of experience as an IP analyst and has worked with diverse companies and teams engaged in IPR consulting, internal IPR team, and the patent search tool development. He has master's degree in biomedical engineering, PG diploma in patent law, and currently pursuing LLB from Karnataka State Law University. He specialized in various patent analysis like patentability, technology landscape, licensing analysis, competitive landscape, validity, and freedom to operate search. He has published multiple articles in various journals, including IAM Magazine and IEEE. Sir, I'm very glad to read your profile to the participants. On behalf of the institution and on my own behalf, I extend a cordial welcome. Next, I would like to welcome Professor Zubeda Begum, Principal Degree College, the most dynamic and versatile personality of this institution. Madam, I deem it a great honor to welcome. I also welcome Dr. M.S. Vidya, NAC Coordinator and HOD Kannada to this program. I extend my heartfelt welcome to all the faculty members of this institution and the valuable participants of today's program. Finally, I welcome one and all. Thank you. Now I request the resource person, Mr. Vijay Krishnan, to continue to deliberate on the theme.
Thank you, Tabassum. I welcome you for this session, our staff secretary. Sir, you can unmute at your end. Vijay sir.
Yeah. Can you hear me?
Yes, sir, we can hear you.
Hope my voice is clear.
Yeah.
Okay. Let me share my screen as well, and let
I
me know
have
once you're...
One sec, sir. I'll stop mine.
Okay. Thank you.
Yes, sir, you can.
So hope you're able to see my screen with the full slide.
Yes.
Okay. Yeah. Thanks a lot for your good introduction, and I'm glad that I'm here to explain whatever knowledge I have to share with you all.
Thank you, sir.
Welcome to Faculty Development Program on Emerging Trends in Technology. So I thought, I think many of you might be familiar with the word intellectual property. So today I would like to cover the program, let's say, from ideas to intellectual property. And the topics that I would like to cover in this session is, like, say, what's the importance of intellectual property? Maybe for few of you, it might be slightly basic, but I would like to cover all the audience. So I kept it slightly simple. and I'll explain the importance of intellectual property in at the global level and what are the various categories of IPR. And then, like say, maybe to keep it more interactive, we'll have a short quiz kind of thing, like say how much you know about IPR, and then we'll have one case study of, like say, as I know that you already had a session on artificial intelligence, so I picked up the same topic and would like to show, like say, how the technology is trending in the area of artificial intelligence. So this is what primarily I'm going to cover today. And like say, to keep it simple, like say, you know what is property. So there are very like say visible and tangible assets like land, buildings, factories, like say all these are tangible properties. But in today's society, it's very important to have the intangible property as well. And intellectual property is one such intangible property. There is no form for that intellectual property. You can only you can't touch or any you can't have the sense of that, but you can, it's creation from a human brain. So that's the intellectual property for you. And let's say, when I talk about intellectual property, many of you will know, let's say, okay, whenever we have some inventions, that's when we can protect it through intellectual property. So to answer a basic question of, like say, why should someone invent, the simple answer is, like say, a better way of to do something, like say, until you invent, you can't grow in terms of the technology, in terms of the society, you can't grow further. So you need to always find a problems that are existing in the society or in the device or in any manner, and you have to find a better way to do something. And for like say corporate companies, it is very important to differentiate their solutions from the competitors or better their solutions from our competitors. Like say, for example, the best example is the Apple iPhone. So how they uh, the phones were all known, like say we all had that like say keyboard phones, but the moment they came with the smartphones, that disrupted the market. So that's how they differentiated their solution from the competitor, and they invented the phone. And similarly, you need to position your market. So like say, for example, iPhone was the first of those smartphones. That's the reason they could capture the huge market potential. So when you invent and when you protect it, you will have the advantage of the market positioning as well, and to become the leader in that area. And the other important thing for all of you who are faculty of various institutes is that the intellectual property provides you, like say, enough resources and knowledge by reading through those documents. Like for example, patents, it has tremendous scientific information embedded in those documents, so you can use that knowledge and contribute to that in your domain. So that's the reason we should invent. And once you invent, they say just invention is not enough. So you should also provide a legal protection for that invention. Let me have a pointer here. So once you have the invention from your mind, so it is very important to protect your invention, because until and unless you protect your idea, you will not have any rights on that invention to claim the ownership. Only if you protect it through the proper channels, that's when you will have the ownership of those rights. So it is very important to have the legal protection for your invention. And as I said, for the inventions, it's similarly, like say, once you have the legal protection, you can stop entry for competitors, or you can stop others from copying your inventions. And similarly, like say, once you have the IP, so you can also commercialize it. It's not only it need not always be used in your products, but you can also, like say, if it is useful for somebody else or somebody else wants to manufacture the similar product, you can commercialize this, you can give it for the licensing. And then that will enhance your company valuation. The more intangible assets you have, the more value you have. Like say, in the current 21st century, it's not just the tangible assets, as I mentioned earlier, like say land, buildings, and so on. It's also the intangible assets, like the intellectual property. Depends on how much intellectual property you own, your company valuation will increase accordingly. And then, like say, if you see the key importance of IPR in the global context, so as I mentioned, it is very important to see, like say, uh, to invent and to get to the creative ideas and invent them. And it's very important to understand this IPR to, and it is very important in policy decisions as well. And because of IPR, so there is a globalization, because once you have an idea, there is no limit for you to protection. So you can protect just in India, you can protect in multiple countries, so that your product, which is protected through IPR, will have the global effect or the global advantage of IPR. And then it also helps through in economic reforms, because like say depending on the intellectual property IP policy, the economic reforms of the country will vary accordingly. Like say, for example, India is the best example in such way. We have very strong IPR reforms, particularly related to the pharma sector. If you see in Western countries, the pharmaceutical products are very expensive, so it's unaffordable for a common man. But whereas in India, if you see the pharmaceuticals or the medicines that that are very much accessible, and the pricing wise they're very competitive in comparison to the Western countries. That is mainly due to our IPR laws, that in addition to the economic reforms that we have made. And because of IPR, you will see the increase in competition, because whenever you file any intellectual property rights, the government will publish them. So because of that, the others will get to see what you have invented, and they will add some more inventions to it. And because of that, there will be very healthy competition between the companies. And it also helps in emerging new technologies. Like say, unless you invent and you give some rights to those inventors, they will not have urge to come up with the new technologies, because until you see the benefit of getting something for your inventions, you will not get into the new technologies. And then the other option is the R&D commercialization, as I mentioned earlier. So it's not only that IPR you need to be used inside your company or inside your college or university. You can also commercialize. There are a lot of universities whom they invent the ideas, protect them, and give the commercialization or give this as a licensing to the companies. And then the other significant importance is the strengthening of technology base, because as I said earlier, particularly patents, they have the strong technical information. So one can read them and get to know a lot of technology information through that. And by the way, if any of you has any questions, like say maybe you can send it through chat, or you can post those questions in between or towards the end of the session. Okay, so coming to the next slide. So this is about IP life cycle. So how does IP life cycle work in an organization? So in general, majority of the institutes or the corporates will have the R&D division or the research division. So they create the IP. Once they have the ideas, they protect the IP. They create those ideas, and then they will file it with respective government departments, and then they'll get the protection of those IP. And once they have it, so they can use it on their own, or if they don't find it useful, they can always license it. And once they license it, they'll earn revenue from there, and that will go again into the R&D for further creation of intellectual properties. And how the industries and society are linked through this IPR is that, like say, once the industry has the IPR, or like say R&D department has the research fund, they will invent, and the technology is used by industries to develop new products and give it to the society. So the society gains in new products. It can be in terms of ease of use, or it can be in terms of revenues. And once let's say the money or the profits that are received from the society will go back to the industries, and what industries does is they receive royalty from IPRs, or they whatever profits they have, they will spend. They'll have specific R&D expenditure, and they will use that and to further develop new technology. So this is a kind of cycle where once you get the profits, you put it into the research and develop more products, and again you get into the new products, and the society will get benefited from that and go on. So this is the key importance of IPR. So maybe in the next slide, I'll tell you, like say, what are different types of IPRs. I think most of you might be familiar with it. To keep it simple, say like say, whenever a company or the institute, they will have the IP portfolio management plan. So within the IP portfolio, it's not always patents. Like say, there is a misunderstanding that IP means only patents. Definitely not. So patents are only provided for specific inventions. There are trademarks which companies protect to maintain the goodwill of their company mark. And then you have the copyrights, where like say, a lot of you as a lecturers or as a faculty, you might publish a lot of journals, so that's your copyright. And then domain names again is very important. A lot of companies ignore this. Like say, whenever you have any product, you have to register the domain name of your company as well as the as well as the product. Otherwise, the somebody can cheat you by using your similar domain. And the other part is a trade secret, which is slightly different from the rest of this, where I'll explain each of these in detail in further. And aesthetic value of the product is protected through the designs. So now let's see what are patents. Let's say, as I mentioned earlier, patents are mainly provided for the inventions. And what does patents provide as a for a person or for a company? So they provide a negative rights. So negative rights in the sense, let's say they will provide to exclude others from making, using, selling, offering to sell, or importing an invention for a limited period of time. So it means that once they have the patent registered under their name, so what they can do is they can exclude others from making, means like say from manufacturing, or using that product, or using the product provided in the technology patent, or selling that product which is covered through the patent, or offering to sell, or even for that matter importing is also banned. But it is only for a limited period of time. Why the governments are providing this exclusive rights is that because the inventors or the companies are making the disclosure public, or they're making the disclosure to the public, to the public of the invention. It means that once you file an application to the patent office, they'll publish it to the public. So it means that it is available for all public to access that invention, so that they will get a new ideas based on that inventions and improve that further. And to get this protection, there is certain criteria, which is that the invention has to be novel, and it should have an inventive step, and it should have an industrial applicability. So if you see, these three terms are very important. One is novel, which is new. Inventive step, it means that it is not obvious to the person skilled in the art. Let's say, for example, today there is a bicycle with 2 wheels. Let's say tomorrow I'll invent a bicycle with 3 wheels. So it might sound very obvious to the person skilled in the art. So you should always show the technical advancement and economic significance. Until and unless you prove that your invention has these two factors, you will not be allotted the patent rights. And the other thing is the industrial utility. So this is again very important characteristics. Unless you show that your invention can be used and benefit the society, the patent officers will not grant that monopoly rights to you. And generally, these monopoly rights will be provided by the national patent offices. Like say, for example, to protect your invention in India, you have the Indian Patent Office. Like say, for example, you want to protect your invention in US, you have the US Patent Office. Similarly, if you want to invent your invention in Europe, you'll have European Patent Office, and similarly, you have it in various other countries. And generally, as I said, these rights are provided for a limited period of time. How much time? So this is 20 years from the date of filing. So once you file the invention, you will have the protection for 20 years after it gets registered. And once the patent is issued or registered, you can have all the rights that I have explained earlier. And if you see here, these are some of the examples that are protected by the patents, like say the robots, the drones, the phones, the technology inside the phones, aircrafts, fans, or turbines, all these are protected through the patent rights. And these days, in a digital world, I'll get a lot of questions: is software patentable? Because there are, let's say, without computer programs, literally nowadays there is no product. Earlier, let's say, as defined by Indian patent law, so generally the software as such is not patentable. It is protected through the copyrights, or you can protect it as a trade secret. But with the changing times, the IP law also is changing. So there is a recent case law where the court has clearly mentioned that the softwares can be patentable if you show the technical advancement. Like say, for example, you take a simple electric car. So electric car can't work without any software embedded in it. So, but there is a significant technical advancement is there in that. So then if there is a technical advancement, even the software can be patentable. So my suggestion is that whenever you think you have solved certain problem which is existing using software, then it is better to approach IP lawyer or IP resource person and see and claim his advice whether it can be patentable or not. It's not generic, but it depends on case to case. But if you are software that you have developed has technological advancement and economic significance, the patent office will approve that idea. Okay, so this is again, if I go, because patents or techno-legal, I call them as techno-legal matters because it has a lot of technical information. At the same time, you have to satisfy the law as well. So the section 2 of Indian Patent Act defines the invention. So it should be a new product or it can be new process, and it should have both inventive step and industrial application. This, I think I explained them in my previous slide. And generally, whenever they provide you a patent, it should be a unity of invention. It should be a single invention concept. So like say, for example, if you are inventing a simple pen, so it should be a single inventive concept what you are defining in your patent application. And let's have a small puzzle here. So you all know the glue stick, right? You will use day in and day out all the glue sticks. So this invention, what they have made is, instead of glue, they had put the glue in the form in place of glue, they had put the butter, and they have used the butter stick, which is very useful for applying the butter on the bread, which we struggle most of the times. We have to take some other utensil to, like say, spoon or something else to apply the butter. So do you think it as an invention? So if any of you have comments on it, maybe you can post them. Then again, I'll go back to 3 parts: novelty, utility, and non-obviousness. These 3 criteria have to be satisfied to say this as an invention. Let us come to the novelty part. Is it novel? Yes, definitely. So I have not seen earlier where the butter is put it in the stick type. And is it is there a industrial applicability? Definitely it is there. Like say, many of us can use it and the industries can manufacture it for usage. The third important criteria comes is the inventive step. Does it have the inventive step? Because it is mere changing of the glue with the butter. But so that's where you have to show your potential, saying that this is not very obvious, because to keep the butter in the form of the glue, it needs a lot of things to be processed. And then once you satisfy, or once you are able to prove all the 3 things to the patent office, they will provide you the grant. So you can see on my screen on the right side. So this is a US granted patent, similar butter stick, where you can apply it on the bread. Let's see one more example. So lawnmower. So we all know about lawnmower, where they used to clean the lawn using the manual or motorized. But in this case, a person is riding a bicycle, and when he's riding the bicycle, the lawnmower is moved and the lawn is cleaned up. So again, I'll come back to those 3 steps: novelty, utility, and non-obviousness. Definitely novelty is here. Utility is there, like say, where it can be manufactured by industries and used by the society. Non-obviousness, because lawnmowers are also known here and the bicycles are also known here. It is mere combining of 2 known things and bringing out the new invention. Again, whether it qualifies for the invention from the patent office, again, there is a similar patent granted by the US Patent Office, where if you see the title, it is very interesting. It's called as exerciser mower. So it means that the person is burning calories and at the same time he's cleaning his lawn. So it is very important for an inventor to show all the 3 criteria of utility, non-obviousness, and novelty. Then you will get your patent granted. And then, so why do we need patents? It's a similar criteria what I've explained earlier in terms of, like say, IPR as such. So it encourages industrial development. So you get to see new inventions from the industries, and the industries will get developed. And it encourages complete disclosure, because you will get a patent only if you disclose your idea, and the disclosure should be in such a way that a normal person in the art should be able to replicate the invention in the physical form. So that's when you will get a protection. You should elaborately explain the invention in a very clear manner. So because of that, others will be able to read those things, and then they can try to implement, or so you can't just copy that, because that's a infringement of IPR. So you can improve that technology which is already disclosed, and you can get the rights granted for that incremental invention. It's not that patents are always provided for the new inventions. Like say 95% of the documents, or 98% of the patents or provided for the incremental inventions. Let's say today I invent, let's say, a pen. So tomorrow I'll invent a feature of this pen where it reduces the leakage of the refill, which is very important for the academics. So those incremental inventions are also protected through the patents, and it prevents duplication because everybody knows what the company or what the person has invented, so he need not invent the wheel again. So it prevents the duplication, and it also, again, so at the end of the day, it all matters is the business for the companies. So how the IPR brings in a lot of commercial value to the company. So that's the reason why all the companies are very much interested in IPR. And it prevents exploitation of researchers. So what happens is, let's say, a lot of times researchers publish articles, and once they become to the public, so you can't protect them. So the others can easily use them, or without any legal stringents, so they can use those ideas. So it's very important for the researchers, whenever you think that idea is novel and it is useful, it's always good to protect it through patent or file a patent application before publishing it. Because I know I'm contradicting a lot of you, because you're very eager to always publish the information. But I advise, whenever you think you are doing something new or incremental, or you are solving some problem, it's always good to protect it and then publish it. And it's again, one more importance is to generate the revenue, and it is very good source of technical information. Like, say, I can say from my experience that it's very helpful. The information that you have in patents is very useful and very helpful to understand the technology. And let's see some examples of patents. Like, say, we all know Thomas Edison has invented the bulb. So here is a proof. Like, say, how do I know that Thomas Edison has invented the bulb? Because he has protected his bulb design through the patent rights. So you can see the Thomas Edison's right. And similarly, we know the Wright brothers has invented an aeroplane. So how? This is a proof. They have the patent application on their name, or the patent on their name. Similarly, Graham Bell, who invented the telephone, so he has a patent on this. And Steve Jobs, we all know he's the modern guru of phones, so he has invented iPhone. So this is one such patent granted patent document. And this is a 3D printer example, like, say, where you have protected the 3D printer. And see, I can say these are breakthrough inventions. It need not always be the breakthrough inventions. It can be very simple inventions. Like, say, for example, this one, we all use the tapes every day. So what they have done is, they have done a simple invention where there is an adhesive area at the ends of this, and that's the only area which gets sticked. All other area is unstickable. So this is a very simple invention and very useful. So these kind of inventions also can be protected through patent filings. It need not always be a big inventions. Like, say, simple paper clips, they are also protected through inventions. And let me tell you, these paper clips, like, say, when I researched, it's not one or five. There are hundreds of patents protected for this simple paper clips. Whenever there is simple improvement in these paper clips, they'll get protected. So just keep it in mind that the patents are not only just for simple breakthrough inventions. It can be for the simple inventions or simple improvements as well. So this is about the patents. And just to brief you about the patent application process. So let me not go into the details of what are these various type of applications. So once you file a application with the patent office, so what they do is they'll publish it. As I mentioned earlier, because you are publishing it, you are getting the monopoly rights. The patent office, by default, whenever you apply any patent, they will publish it. And once they publish, you have the time for pre-grant opposition. Means, like, say, anybody person who is interested in the technology, he can oppose, saying that whatever whoever has applied for this patent, it is not new, or it is not non-obviousness, so you should not grant the right, so it might get rejected. Or you should request for examination. So patent office will have the examiners who will examine your application. So, and then they'll examine your application and tell us whether it is novel, of non-obviousness, or it has utility, and then they'll provide you the examination report. So the examination report generally will have the objections by the patent office, why they don't grant it the patent office. So you need to respond to the office action, and once you compliance with it, they will grant the application. If you don't comply with the office action, it gets rejected. And once you get it granted, again it gets published. Again there'll be 1 year timeline to to grant to oppose this application again, and or you can even challenge it in the courts that this is not a new, and the patent might get rejected again. And the other thing that is there in patent application is that once you get a granted, you need to do the annuity payment. Like, say, this is we call it as a maintenance fee. So to maintain your patent application, you need to pay certain amount to the government. It's very small amount, so you need to pay that to the patent office. So this is all about patents. And then I'll go to the next one, which is trademarks, which is very hot nowadays in India. So trademarks are generally provided to distinguish from your goods or services from one enterprise to the other enterprise. So let me take an let's say, interesting case study here. So we all know the Starbucks coffee. So we all know how the logo looks like. So you have the Starbucks on the top, coffee on the down, and then you have the queen with the crown here. So somebody in India has started Sardar Baksh coffee with a similar design. Like, say, instead of queen or lady with the crown, they changed with Sardar with the turban, and they have applied for the what do you call design rights, or they have started their company. But Starbucks has filed a suit on Sardar Baksh coffee saying that they are infringing their design rights. And then the design office or the court has rejected this, and they have stopped them using from this design. That's when what they have done is they have modified this complete design into this. And again, still Starbucks has went behind them and asked them not to use this. But court said it is clearly distinguishable. If you see from this to this, this is nowhere, let's say, similar. It is completely different. This design looks completely different. That's when court said that it is distinguishable enough. So the Sardarji Baksh coffee could get the design rights for this, but not for this. So trademarks, it can be a symbol, it can be a word or words, legally registered or established by use as representing a company or product. Like, so you might have seen Yahoo, BMW, HP, McDonald's, for that matter, our own company, Philips. So all these are protected under the trademarks. And in India, we also follow well-known marks. Let's say there are very few marks which are very well known. So it need not be formally registered, but the trademark office of India government has recognized them as well-known marks. So for those, you need not formally protect them, but they are by default protected. And let's say what happens between the registered and unregistered. Let's say I know a lot of companies and a lot of small companies and shops, they'll not register their trademark. They'll just go and start using it. But what will happen is, if you are infringing that, then it will become very difficult. Or if you don't register it, if somebody comes up with a similar design tomorrow, so it's very difficult for you to prove that you are using it from the beginning, because you are the first user of the trademark. So that becomes very challenging. So that's a key difference. It's always good to register the trademark, because once you have the register, you have the registration proof from the government saying that you have that proof, and you need not bother much about the later part. And if you see how the application process of trademarks happens, let's say first you file an application, and the trademark office will examine and give you the report, and within 1 month you have to file a reply. If the office is satisfied with your approval, they will accept the design, and it gets published. And they'll wait for 4 months for the opposition if anybody wants to file opposition, so that they'll give chance to the others also to oppose it. And once they don't hear from anything, it gets registered. Or let's say if somebody opposes it, so the office informs both the applicant as well as the opposition person who has opposed it, and they'll reply, they'll give you the notice, and you need to respond to that notice. And once, if the opposition is rejected, you'll get the registered. If the opposition is upheld, you will not get the trademark. So now the next important part is the design. So I explained about the patents. The patents are mainly for the inventions. So designs are mainly for the aesthetic view. So the look and feel of the product, like say for example, this is a jewel, or it's an ornament. It's the design of the car, design of the phone, for that matter, simple chain, or like say there you can protect the design of the simple bowl that you use in kitchen, or kettle, or the smartwatch. So all these, the aesthetic view of this can be protected through design. So when you see the definition of the design, it is the features of the shape, configuration, the pattern, ornament, the composition of lines, colors, or anything applied on any article. So this is very important here. So you can't have some random design. It should be able to apply to a specific article, and it can be either in two-dimensional form or three-dimensional form, or it can be industrial, it can be used by industrial process or manufactured by industrial process, or by manual, mechanical, chemical. It can be anything. And the other important thing is it should be appealing to the eye. So you should be able to judge it by eye. So that's when you get the design protection. So as I mentioned earlier, so it can be either two-dimensional design or three-dimensional design. Like say two-dimensional design like wallpapers, it can be protected through designs. And you have the patterns on the textiles. Like say, if you know the Mysore silk saree, they have the specific mango leaf design. So that can be protected through the designs as well. And the three-dimensional designs of the chairs or any product, you can protect them through the design mark. And similarly, like say, there are certain criteria for protecting as a design. It should be new, and it, as I mentioned, it should be related to the features of shape, configuration, or anything, and it judged solely by the eye. And it should not include any trademark or property mark or artistic mark which is defined under Copyrights Act. So once you protect through the copyright, you can't protect it through the design here again. And this is a simple process of the design. Again, it's similar to what you have seen in the earlier process of patents and trademarks. So I'll not go in detail into it in the interest of the time. So now again, one more interesting topic is the copyrights. So till now, whatever we have seen, we call them as industrial designs, like say patents, designs, the trademarks. These are all used in the industries. Whereas copyrights, it need not be used in the industries. It can be for the individual as well. So what will be protected through the copyrights? So the copyrights are exclusive and assignable legal rights given to the originator for a fixed number of years again. And he can print, publish, perform, and various acts can be performed by the owner of the copyright. And the important thing here in the copyright is it is not the idea that is getting protected. It is the expression of an idea that is getting protected through copyright. And if you see the term of copyright, it is 60 years. And various examples include software code, web information, user manuals, product package information. All of them are protected through copyrights. And I know you might be wondering, what is this books piling up here? So let me give you an important case law here. So what happened is, Delhi University has made a curriculum saying from, let's say, whenever you made a curriculum for the specific subject, you give a lot of references from different books. So there is one photocopy services in a University of Delhi called Rameshwari Photocopy Services. What they do is they take the information from various books, sorry, and they match the curriculum of that subject, and they were using it. The Delhi University was using it. And University of Oxford has filed a suit on them saying that they are infringing their copyrights because they own their books. They own the copyrights of those books. And the court, you know what happened in that case? The court held that this is not infringing because they're using it only for an instructional use. They're not using it for a commercial use because it is used only for the educational use. So it is not infringing. It is not considered as an infringement. This is very important landmark judgment. And most of you are familiar with, let's say, Ilayaraja and SP Balasubramaniam copyright dispute. So what happened is, like say, SP Balasubramaniam went to the US to perform a stage show, and he generally sings a lot of Ilayaraja songs. If you are familiar with the southern musical industry, Ilayaraja is great music director. Generally, whenever you for those musical work, the music director holds the rights of the copyright. In this case, the SP Balasubramaniam was mere performer. He doesn't own any rights on the songs that he sings, which are made by Ilayaraja. So Ilayaraja had sent a notice to SP Balasubramaniam not to perform because he has not taken a formal approval or to perform those songs. So he had filed, he has sent a legal notice to the SP Balasubramaniam. Later, they, because of their friendship, so Balasubramaniam has taken the former approval, and again he continued to sing his songs. So the reason why I'm quoting these case laws is that it's very important to know what is protected under copyright and what are your rights that are protected under copyright, and use them accordingly. And what is the subject matter that you can provide? Like, say, for example, in patents, you protect inventions. In designs, you protect this aesthetic, your mark. In designs, you protect the external view of that ornament or the product. What do you protect in copyrights? You protect literary work. Let's say, for example, you write a book, or for that matter, you write a thesis, or you write a paper, or for that matter, I'm presenting this. So this is my work. So I can protect it through the copyrights. But because I'm employer of Philips, so whatever I protect, whatever I do it for the company, the company will be the owner of the literary work. I'll get into that little later. Dramatic work, like say people perform in the stage shows, or I'm performing here as in a conference. So this is my dramatic work. So this is again protected under copyright. Musical work, you go back to the example of SP Balasubramaniam and Ilayaraja. So the musical work will be protected by the music directors. Artistic work, like say you draw paintings, you sculptures, all those will be protected under copyrights. Cinematography films, like say the movies and sound recordings. So all these are protected under copyrights. And coming to the important point of, like say, ownership of these copyrights, who owns these copyrights? Let's say, for example, in the patents, inventor is the owner. In trademarks, company is the owner. In designs, again, the companies are the owners. So who owns the ownership rights for the copyrights? The author, who does this literary work or any such work, he will be the first owner of the copyright. But when the work made by author is in the course of employment or for hiring, let's say, for example, I'm a movie producer, I hire a director to make a movie. So he does a movie for me. So then it is not the director, because director is working for the remuneration. So it is the producer who will have the rights of the movie because he is working for hire. In those cases, the employer will get those rights. But because if he does this under a salary or any other benefit, the employer will get the rights. What are the rights that will be provided for this? To reproduce the work, to issue copies, like say, for example, reproduce in the sense, like say, you have the thesis and you reproduce it. So you have to provide the rights to reproduce that work. Without your rights, they can't reproduce it. Or issue copies, like say the publication of books or publication of journals. And perform in public, like say I have the skit with me. So if somebody wants to perform it in public, I have to give them the rights to that skit. Cinematographic films or sound recordings, which will happen generally in the movies. A translation of work. Let's say I make a movie in Canada, and if somebody wants to do a similar one or same one in some other language, I can provide the translation work to them. Adaptation work. So again, there are a lot of cases in this adaptation. Like say, people will copy the novels and they make movies. So it's an adaptation because it's translating from one form to the other form. So you need to take the rights or from the specific owner to make an adaptation. Or the other option is selling, hiring, or offer to sell or copy of. It can be a computer program, it can be a book. So all these ownership rights will be available to an original author or the employer of an author. And again, as is similar to designs, it can be protected or it cannot be protected. But it's always good to protect your registration, because what it does is it provides a legal protection. It increases goodwill because you are marked as, your work is marked as copyright registered. So it will increase your goodwill, and it protects even after your death. Let's say, because even after the death of the person, the copyright extends up to 60 years even after the death. So your legal heirs can inherit the work that you have performed. And this is very important. It acts as prima facie evidence because you have registered this copyright, and you have a registered copyright in your hand. So it's very easy to prove that you own it. Otherwise, you have to show the evidence that you own that copyright. You are the initial author of that copyright. and it provides a global protection. If you protect it, you can protect it in across the world, and it makes a public record, and it establishes credibility in market. And other important, it creates an asset for you. So once you register, it creates a value for you. And now we'll slightly move to the next topic, which is geographical indications. So what are geographical indications? Again, whenever there is a good which possess specific characteristics, quality, and reputation due to the geographical place of origin, so that gets protected through geographical origin. Let's say we all know Tirupati Laddu, or for that matter, our Mysore silk saris, Bidri work from Bidar. Similarly, like say Shimla apples, and I don't know if you have heard about rasgullas. So there was huge fight between state of Odisha and state of Bengal, that who owns the rasgulla. At the end, it went to the state of Odisha. So now state of Odisha can use that word rasgulla. They own that geographical indication. So what's the advantage of protecting the geographical indication? So once you protect that as a geographical indication, no others can use the similar one. Like say, for example, I can't manufacture a sari and say that this is a Mysore silk sari. No, because it's infringement of geographical indications. Similarly, Darjeeling tea. So you should generally what happens is a group of people or the societies, they will take the protection under geographical indication. And again, another important protection way is a trade secret. Like say, till now, whatever we have seen, patents, trademarks, designs, geographical indications, or copyrights. So you are publishing it, then only you will get a protection. Whereas trade secret, if you have something as a confidential information, which you think that it can't be reverse engineered, so you can protect that as a trade secret. So trade secrets are IP rights on confidential information which may be sold or licensed. And in general, to qualify for a trade secret, it should be commercially valuable. So unless it is commercially valuable, why would a company or a person will try to make it as a secret? And it should be known to a limited group of person. And you, as a company, as a person, you should take a reasonable steps that it should know only to a limited group of persons. Then only it is qualified for the people to market as a trade secret. And unauthorized acquisition and use, like say if somebody steals your trade secret from your company, so they will be like say you can file a suit on them and get the damages recovered. And for this, there is no registration process, and it can be held for unlimited period of time. So on the my screen you can see there are a lot of trade secrets. These are very popular ones. The Coca-Cola. So the ingredients of the drink that you use in Coca-Cola, nobody knows it. It's known only within the company, very limited person. So nobody could do the reverse engineer and get the similar flavor out of it. So it is till now the best known secret. And a lot of us use Google these days. The Google search algorithm, like say how whenever you search for a specific thing, it gets populated, the results that you get and the ranking that you get, it is the proprietary to Google. Again, it is protected under trade secret. Nobody else knows this. And the KFC, the recipe of the KFC chicken, nobody else knows it. Very limited people know it. It is protected under trade secret. And now if you see, like say, I explained you various things like various IP rights. So do you need to protect all the rights? Like say, whenever you see any product, in general, it is protected under all the processes. Like say, for example, whatever technology that is there inside the camera, in Canon camera, it is protected through the patent. Like say, automatic exposure control mechanism, it is protected through patents. The appearance of the Canon, like say how it has the bumps and the aesthetic view, it is protected through designs. And the user manual of the camera, which will explain its features in detail, it is provided through copyrights. And the domain name .in.canon, it is protected under domain name. And Canon that you see on the camera, it is protected through camera. And then the trade secret, the autofocus technology of camera is protected through trade secret, and majority of them don't know about it. Similarly, when it comes to the phone, so again, the phones are also protected through various rights. Like say it can be protected through patents, copyrights, trade secrets, designs, and trademarks. Again, I'll go back to the example of Coca-Cola bottle. So I explained you that the ingredients of the drink that we use is protected through trade secret. They also protected the trademark, the Coca-Cola, and they also protect the various advertisements and the manuals, and the material that they use for advertising is all protected under copyright. They also have a lot of patents. Like say, for example, you know the cap of the Coca-Cola. So once you lock it by the industry, once you open it, you can't tamper with it. You can't fix it again. So that technology is protected through patents. So what I mean to see is, whenever you have as a company or as a university, if you think of any product, so you should think holistically and across the IP models. You should think about what you can protect through patents, what you can protect through designs, and what you can protect through copyrights. So whenever you have an idea, so you should provide a certain form to that idea. So if that form is in terms of the invention, you protect it to the patent and apply for patent of the invention. And once you have it, you will get a protection for 20 years. And then my tip, I already explained this. So without protecting your invention, don't go to the public and publish them. And some examples are Bluetooth technology, GPS tracking systems, and so on. And if you think your product has a unique brand, then you protect it through the trademark. It need not be the company name. Let's say, for example, Surf Excel. Surf Excel is the product name. It's owned by Hindustan Unilever. So that brand you can protect through the trademark. And the aesthetic design you can protect through the designs. And whenever you have, sorry, somebody has a question. Okay. Yeah. So somebody has the literary work or the manuals and all can be protected through copyright. And if you have confidential information and you know that somebody can't infringe your rights, you can protect it as a trade secret. Okay. So I think in the interest of time, I'm not sure how much time I has. I see that the clock is 3:29.
Yes, sir.
Yeah. So maybe I'll complete it in a minute or so. So like say, whenever I thought I'll have it as an interactive session, but let me go quickly. So let's say if there is a property, intellectual property created by artists, so what it get protected under? It is protected under copyright. And just to let's say regain your memory, so if it is protected by designers who designs a specific models, it is protected under registered designs. And then whenever somebody has an inventions which is protected, which is created by inventors, it is protected as patents. And then if somebody has an original story and they want to sell those copies of work, so what do they do? So they protect it as copyrights. And let's say a sports team has been set up, like say, for example, Royal Challengers Bangalore, and they market it and they sell the clothes on the name. So what do? So they will trademark the name of Royal Challengers Bangalore and they sell those merchandise. And if the company has a technology and they want to improve the technology, what do? They protect that improvement through the patents. And this is like say a little complex idea. Let's say somebody has a uniquely shaped walker for senior citizens, which can be collapsed and can be used as a chair. So what are the various things that they can protect? They can protect it as patents, they can protect it as trademark, and they can protect it as industrial designs. Yeah. So with this, maybe I'll conclude my session. So if you have any questions, I'll be happy to answer.
Participants, if you have any questions. Participants, please raise your hands if you have any questions.
Yeah, I think it was clear.
Yeah. So in the chat box, we had one question in the earlier that patents is possible for science. And so if you wanted to answer for that.
Let me go to the question exactly.
So you can just.
Yeah. See, patents, it need not always be science. So anything to do with the technology, or if there is a problem in the existing, and if you solve that problem through your invention, that can be protected. I'm not sure exactly what you mean by humanities here. Generally, science and technology are protected through the patents.
Humanities comes under the art section, sir.
Yeah, so then you can protect it through copyrights.
So anyone else have any more questions? So you people can please raise your hand. I can unmute you at my end. Thank you, sir. Thank you for such an interactive and such an informative session about the patents.
Thank
It was
you. It was my
great
pleasure.
to you, sir. So we have amongst us and another great personality, which today's 5 days program would be incomplete without the valedictory session. So we have amongst us another personality, Janab Farooq Mahmood, sir. Sir, there is a vice president of the CMA, Karnataka. It's my honor to welcome you. It's my honor to welcome you for today's session, sir. You can just turn your front camera, sir.
Yes, ma'am. I'm sorry. Let me just turn this round.
Just turn on the front camera.
Keep it open. Picture. With the picture. It's going the other way.
So
Oh, yeah, sorry.
That's okay, sir.
Good afternoon,
Sir, to
ma'am.
proceed for the valedictory address. So over to you, sir.
Thank you very much, madam. Good evening, good afternoon to all the staff of Abbas College and the valuable inputs given by the speakers, Professor Radhakrishnan, Professor Dr. Geeta Prakash, Mr. Munawar Ahmad, Ms. Nikhil, Mr. Dr. S.K. Aruni, and Mr. D.V. Vijay Krishna. I heard his presentation a short while ago, and I think it's a great opportunity that the college has done this, and more such sessions like these are required for the students to interact and understand things. I would first appreciate the initiative taken by the college and its staff and other members to do this. And I think they should do more of these functions so that our students are updated on technology and what's happening around it. I'll just say my 2-bit short and I'll complete it to let you guys do what you have to do. But emergent technology plays a vital role in the modernization of industries. New technologies help in transforming enterprise into a digital world. This technology is mainly helpful in manufacturing, energy, and mobility markets. Technology will always be an integral part of our lives, and its role in our overall growth is only going to increase in the coming future. After a long pause due to the pandemic, 2022 is the year of new tech trends, from the continuous discussions of digital technology to the increasing popularity of 5G networks. This year, the internet is faster and smarter than ever. Emerging technologies include a variety of technologies such as educational technology, information, nanotechnology, biotechnology, robotics, and artificial intelligence. I'm sure you've discussed all these subjects before I've joined you, and I'm sure the students would have got a very good insight in this. 2020 has taught us many things. One of these things is that technology, if used right, can help improve our lives in numerous ways. When bank offices and practically everything else was shut down due to the pandemic, it was technology that saved us from going insane. We managed to survive the worst with the help of video calls, group meetings, digital money transfers, video streaming, and other tech solutions. And now that the worst is over, it's time for us to upgrade ourselves to include the newest technologies in both our work and our personal lives. So what the new upcoming technologies that are worth considering for those looking to create a next-gen solution, as well as those looking to upgrade their their career skills. Impact of emerging technologies on society. In a world driven by digital solutions, emerging technologies continue to affect the way we live, work, and interact with one another. Many of these technological changes are great. They increase our productivity, make the services we need more accessible, and overall makes our life easier. Barring out a few things, that is, most people in the tech industry were telling me the wives were complaining that the husbands were ordering them to bring tea and food, and the other way around, the mother-in-law was staying at home and going through this entire mundane conversation. So some families have had tough times managing and coping with working from home. But overall, I think it's a fantastic thing that's happened. Some of the advantages are easier, faster, and more effective communication, better, more efficient manufacturing techniques, less wastage, more efficient stock management and ordering systems, the ability to develop new innovative approaches, more effective marketing and promotion, new sales avenues, the influence of technology on the living of a human life. Technology affects the individual, communicate, learn, and think. It helps society and determines how people interact with each other on a daily basis. Technology plays an important role in society today. It has positive and negative effects on the world, and it impacts daily lives. They include artificial intelligence, augmented reality. I'm sure you know the AI and AR, blockchain, drones, Internet of Things, IoT, robotics, 3D printing, and virtual reality VR. Today, the essential eight continue to evolve and make their mark, with this pandemic accelerating emerging tech adoption. If it wasn't for this pandemic, I think we would have taken another 20 years to develop these technologies, but this has happened. It's accelerated its speed because of the way things, I would say this is one of the positive things that the pandemic has created, is the advancement of technology and the way we use it. The 6 emerging technologies that will change the world, as you're all aware, is big data, artificial intelligence, self-driving cars, blockchain, virtual reality and augmented reality, 3D printing. All these are the top list as fastest growing technologies for 2022 and beyond. The technology paradigm is shifting very fast due to the fastest growing technology today. It is only by accepting the new technology evolutions and adapting ourselves and our business processes according to them, we can ensure optimal future growth. I thank you for giving me this opportunity to present my 2-bit on what you guys have worked out on. I must share with you, I saw a WhatsApp message this morning. Saudi Arabia is coming out with a city in its plan, I think in 2030. It's known as NEOM. It's a 170-kilometer long city with, I think, 37 kilometers, and it's going to house about 9 million people with zero carbon footprint. So this is something fantastic, zero carbon. And it's accessible to 40% of the world within a 6-hour flight. So countries that were seen as not so advanced in technologies are now becoming world leaders and world innovators in how they want to do things. So I think we've got the resources, we've got the human power, we've got the capital. And, there was a recent survey, which is an unofficial thing, which I was told, that most of the Fortune 500 companies, their CFOs or CEOs, close to 80% of them are Indian or of Indian origin. So that alone shows to us that how much the world is dependent on India, Indian technology and Indian minds to move this world forward, to be a better world, to serve humanity and to serve everybody so that we all live better. Thank you, ma'am. Over to you. And if there are any questions, I'd be more than glad to answer.
Thank you, sir. Participants? Participants? Anything? Thank you, sir. Thank you for your great valedictory address for this 5 days online national level FDP on emerging trends in technology, its future perspective. It was great to hear you, sir. So you had briefed us about the current technology which is running around. So thank you much, sir. On behalf of college, management, principals, staff, and my own behalf, I extend a warm gratitude to you, sir. Thank you for joining for this valedictory.
Thank you, ma'am. Thank you all
sir.
the speakers and the children who have attended this, and I wish you all the success. And Mr. Vijay Krishna, I heard your address, very informative, sir. I'm sure the students would have learned a lot from what you have discussed.
Yeah, thank you, sir. Thanks a lot for your thoughts.
Thank you, sir.
Thank you. You want me to disconnect? I can leave and you can continue your program. Or is there anything else that you need of me?
No, sir. Thank you for your validity. No, sir, you can carry on. Thank you for your precision.
Thank you.
Thank you.
So, thank you. So it's my pleasure to extend my warm gratitude to the speaker of today's program, Mr. D.V. Vijay Krishnan, IP analyst and Indian patent agent, Philips India Private Limited, Bangalore. Thank you, sir, for deliberating us, giving us the idea of your IPR and how exactly the IPR is there in today's market. So thank you on behalf of these college staff, management, and everyone present here. I extend my deep gratitude to you, sir.
Thank you. It's my pleasure taking you all through IP.
Thank you very much, sir. So it's my honor to thank all the speakers of all the 5 days, which we had a great session and the great knowledge is shared among all the participants. I hope the session was useful to all the participants, and I thank all the speakers of all the 5 days. I'd like to extend my deep gratitude to our principal, Professor Zubaida Begum, who is the backbone of organizing all the events. Ma'am, on behalf of everyone, I thank you, ma'am. I would like to thank another great leader, Dr. M.S. Vidya, IQAC coordinator, HOD of Kannada, for her coordination, support, and guidance in organizing and making this FDP program a grand success. Ma'am, I take it a pleasure to thank you on behalf of everyone present here. I would like to thank our dynamic staff secretary, Dr. S.G. Saida Tabassum, for her cooperation and support in organizing this event. I thank Rumana Tabassum, treasurer, staff treasurer. I take it a pleasure to thank Mr. Vijay Kumar, lecturer, department BCA, and Ms. Habiba Saida Aisha Siddiqa, HOD of history, for supporting in arranging this FDP program. I would like to thank all the HODs who have contributed in this FDP program in arranging the speakers and in direct or indirect support in conduct of this event. I take it a pleasure to thank, last but not the least, all the participants of today's program. So participants, thank you for joining. Thank you for making it a grand success. And participants, you could find your feedback form link in the chat box. So no personal feedback link will be sent to anybody, nor in the group. It is only available in the chat box. You people can take it from the chat box. Feedback link is available in the chat box. So participants, thank you for joining and making the program successful. Last but not the least, I thank all the teachers, lecturers, staff of our college and the non-teaching staff of our college for supporting it. Thank you. I hope all the participants have got the feedback link. So feedback link will be available only in the chat box. No personal feedback links will be given. So all the participants can take the feedback link from the chat box. So you will be getting an auto-generated certificate from this link. So you people can fill the feedback and get the certificate, and please insert the correct email ID for generation of the certificate. I hope all the participants have taken the feedback link from the chat box so that we can end the session. Once again, thank you everyone.